Hello, I am Stephen Flott, the principal of Flott & Co. PC in Arlington, Virginia. Today I want to talk about U.S. citizens living outside the United States who are surprised to learn that they have U.S. tax and bank report filing obligations and as a result are facing some compliance issues. Obviously, this is not likely to be pleasant news. One way to react is to take the ostrich approach. Stick your head in the sand and hope the IRS never finds you. Or take comfort from the fact that you are a long way from the United States. What can the IRS do to you anyway? Until recently, this approach worked more often than not because the IRS had not been particularly active in enforcing tax filing and bank reporting requirements on U.S. citizens living outside the United States, especially long-term non-residents. The UBIS scandal in 2008 changed that. Several foreign banks specifically marketed their services to U.S.-based clients, offering to set up bank accounts located outside the United States as a way to enable them to evade U.S. taxation and hide assets from the IRS. When the scheme was discovered, it caused a political storm in the United States and also created pressure on the Department of Justice and the Internal Revenue Service to go after these tax cheats. The political fallout led the U.S. Congress to enact legislation, the Foreign Account Tax Compliance Act, FATCA for short, which has dramatically changed the landscape for all U.S. citizens, but most particularly for those who are residing overseas. As a result of the UBS scandal, Congress passed FATCA to put the heat on U.S. citizens who are using foreign bank accounts in bank secrecy jurisdictions to evade U.S. tax by forcing banks located outside the United States to report U.S. accounts to the IRS. As collateral damage from this approach, FATCA has its most direct impact on U.S. citizens living overseas because, not surprisingly, their assets in bank and financial accounts, savings, etc., are generally located where they live. Even though 99.9% of these citizens are not really targets of the FATCA crackdown, FATCA profoundly changes their ability to hide from the IRS. The second problem for U.S. citizens living outside the United States is that the United States taxes based on citizenship, not primarily on residence, like the rest of the world. So U.S. citizens are subject to U.S. tax laws regardless of where they live or where they earn their income. They are also subject to bank report filings and the individual tax requirements of FATCA. U.S. citizens who were born in the United States are going to have the evidence of their place of birth stamped in their foreign passports and identity documents. Thus, even though they may be citizens of other countries, dual nationals, as it were, of the United States and another country, U.S. law considers only their U.S. citizenship. Thus, a person born in the United States, regardless of his or her other nationality, will be instantly marked as a U.S. citizen, regardless of what passport they carry. For example, a Chinese, Indian, or Singaporean passport will show the holder to be born in Boston, Chicago, San Francisco, instantly identifying them as U.S. citizens. As of July 1st, 2014, foreign financial institutions are required to put in place procedures to identify U.S. account holders when new accounts are opened at their institutions. By the end of the year, they will be required to file reports on pre-existing accounts in their institutions with balances of $1 million or more. That amount will drop to just $50,000 by the end of next year. Financial accounts include foreign mutual funds, insurance policies, bank accounts, and other foreign financial assets. If you are not compliant with your U.S. tax and bank report filings, you need to act soon to remedy the situation, particularly if you were born in the United States. You have the benefit of the doubt right now if you take action before your accounts are reported to the IRS. The longer you wait, however, the less persuasive the argument that your non-compliance is innocent will be. A claim of innocence fades over time. The longer you wait to comply, the weaker your assertions of innocent noncompliance become. The United States has signed FATCA intergovernmental agreements with more than 20 countries and is negotiating agreements with another 75. Right now, U.S. citizens living in more than 95 countries around the world will soon have the foreign financial institutions in the countries where they live complying with the account reporting demands of the new FATCA regime. And by the end of next year, have any accounts that exist in any of these institutions with balances in excess of $50,000 reported to the IRS. The ostrich approach does not seem to be appropriate in the circumstances, and the consequences can be quite harsh. The time to act is now. As the old saying goes, a word to the wise is sufficient. If you would like more information on U.S. tax and bank report filing questions, please visit our website at www.flotco.com. Thank you.